Hello, and thanks for joining me. And thank you for watching this video. This is my video to cover the offer to purchase and contract. I'm not going to hit every single thing here and read it all to you. A lot of this straightforward. I'm going to hit the more complex pieces of the North Carolina offer to purchase and contract. Okay. One thing that I want to say in the outset, there are no contingencies in the offer, in the North Carolina offer to purchase. So we'll get further into that as we go. So on the first page here, very important, we want to know who the seller is, want to know who the buyer is, also want to know where the property is. So we're going to identify that property as specifically as possible beyond just the street address. We also want the legal description and all these things. Now, I will fill the entire offer out. We will discuss all the purchase price, due diligence, and all these things. The entire offer will be filled out when you receive it. The only thing to do is review it, ensure that it is accurate, and sign. All right. On the first page as well is all of our financials. So we've got our purchase price, right? What are we willing to pay for the property? Line there is the due diligence fee. We've probably already talked about this, but quickly, the due diligence fee is paid directly to the seller, and it is your payment to the seller for them to take their house off the market while you do your due diligence. One more thing about due diligence fee. Due diligence is non-refundable. Just want to make sure that that's clear. Initial earnest money deposit. The earnest money deposit is a deposit that's held in escrow until closing, right? So the closing attorney is going to hold that in trust until, or in a trust account until closing, okay? If you close, or when you close, let's say, both due diligence and earnest money are deposits, right, that will credit against the purchase price. If you do not close and you terminate the contract prior to the end of the due diligence period, then you will get your earnest money deposit back. If, however, you terminate the contract after the due diligence period, then the earnest money is also going to be kept by the seller. All right. The rest of these don't really apply in most situations. If they do, we already talked about them. But those are all the financials, okay? The due diligence and the earnest money are pretty much due at contract. You do have 5 days to get in the earnest money. However, it's usually just easier just to go ahead and pick up all the checks at once, okay? And this is a description. Money deposit, again, that's going to be held in a trust account or in escrow until closing. Now, if you, again, terminate the contract prior to the end of the due diligence period, then your earnest money deposit will be refunded to you. If, however, you terminate after, then the earnest money will be kept by the seller. The escrow agent, in this case, is going to be the attorney who closes the transaction. So we'll put their name there, and that is who you will make the check for the earnest money out to. Okay. If there's a problem about who gets the earnest money, if a termination happens, then the escrow agent will hold on to it until that dispute is resolved. Excuse me. The effective date of the contract is the date that both the seller and the buyer have signed. Okay. The due diligence, this is important. This is the buyer's opportunity to investigate the property and the transaction contemplated by this contract, including but not necessarily limited to matters described in paragraph 4, to decide whether buyer, in buyer's sole discretion, will proceed or terminate with the transaction. That is your due diligence period, right? The due diligence fee is what you're paying the seller. That's what you're paying the seller for that time. Okay. Now, in the market that we're in currently, that's probably going to be about 1% of the purchase price. So just keep that in mind. Not a set fee. You can do it whichever way you want to, but about 1% is what we're seeing right now. Due diligence period is determined by you. You get to decide how long you need to do your due diligence. Okay. Settlement is when you go and sign the paperwork, and then closing is actually when the deed is recorded. So that may or may not take place on the same day. When you go sign the paperwork, depending on the time of day, the attorney may or may not be able to get that over to the courthouse the same day. I point that out because some sellers won't be willing to give up the keys to the house until the deed is recorded, because that's when the actual sale takes place. So keep that in mind. Special assessments. If there are any special assessments, they should have been disclosed, and if there are, then we will move accordingly. Proposed special assessments Confirm special assessments. Again, all of that would have been, you would know about that prior to the offer. Okay. Fixtures and exclusions, important stuff here. I'll let you read through that, but these are all the things that are considered fixtures. Okay. Fixtures convey with the property unless the seller has said that they don't. Okay, it's the seller's responsibility to unpair any smart devices that will convey with the home. Okay, so this is where if there is anything that the seller has identified that won't convey in the sale under D, we would list that out there so that there's no confusion. Okay, and then if there's anything else that's maybe not included up there, but it's also not going to convey, that's where we would list those things so that there's no confusion. Personal property that is going to be transferred to you at closing, that's where we're going to put the refrigerator. If for some reason you're also asking for the washer and dryer, that's where that information would go. All right. This goes into the buyer's due diligence process. Due diligence is going to include all of the things, right? So if you come down here under B and it talks about property investigation, and you can kind of read through all of that, but it's definitely going to be your inspections, our review of documents, you getting your insurance, the bank ordering the appraisal. If you want to get a survey, that would be the time to do it as well. Zoning and governmental regulation reviews, flood hazard reviews, utilities and access reviews, and then streets and roads. Those are all of the things. And there could even be more because you may want to get a general contractor involved in just all the things, but we have to know if all those things have to be a go by the end of the due diligence period so that you'll know if we're moving forward with the contract or with the purchase of the property. Sale or lease of existing property. So this is basically saying that this contract is not contingent on you having to sell a property or lease a property that you own. Then this is probably the most important sentence in this contract. And what it says is that the buyer acknowledges and understands that unless the parties agree otherwise, the property is being sold in its current condition. Now that means that North Carolina is an as-is state and the seller is under no obligation to do any repairs, period. If the seller does decide to do repairs, great, but they're under no obligation to do so, okay? If for some reason, as we are investigating the property, if we on the buyer side accidentally damage the seller's property, then it's going to be the buyer's responsibility to get that repaired. Okay. Buyer's right to terminate. The buyer has the right to terminate this contract for any reason or no reason at all by delivering to the seller a written notice of termination. Okay, during the due diligence period. Seller doesn't have to agree to it. It's just a notice because you're terminating during your due diligence period. They keep your due diligence money. You get back They keep your due diligence money, you get back the earnest money. All right. Closing shall constitute acceptance of the property in its then existing condition unless provision is otherwise made in writing. That means that we need to do a final walkthrough prior to closing to make sure that the property is in the condition that you want it in when we close. Buyer representations. This is where you tell them what kind of loan you're getting and all the terms of the loan. Other property. If you did have to sell a property, then this is where we would have to put that. Again, this is not a contingency. This is a disclosure. So if you don't sell your property, then that doesn't mean that this contract is void. You're still in this contract as well. So you can read through that as well. All right. And this is basically saying that to the best of the buyer's knowledge, there is no other circumstances or no other conditions exist as of the date of this offer that would keep you from buying the house. So that's basically saying that you are financially sound to buy the house. Now, the other thing that we give to support that is your pre-approval letter, right? And then the residential property and owner's disclosure statement. This is where we disclose that we did or did not receive that at the time of the offer. Okay, buyer obligations. If there are any proposed assessments, the buyer shall take title subject to all proposed special assessments. So proposed special assessments would be your responsibility. Again, those would have to be disclosed prior to, okay? And then responsibility for certain costs. The buyer is responsible for all these costs listed here. Some of those are going to be your closing costs. Some of those are part of your closing costs. Some of those are going to be paid up front, like the inspection and appraisal. Okay. Authorization to disclose information. Again, your information, mailing address, name, all that stuff is going to be on this offer. Ownership, we have to say how long the seller has owned the property. If the property was built prior to 1978, we need a lead-based paint disclosure. All these things would be sent to you. If we needed it, I would be sending it to you. And then here's where we say that there are not any special assessments, and there aren't any confirmed proposed special assessments. Okay, if there's an owners association or an HOA, this will be disclosed here on the offer to purchase. And all of this is just basically, so this is basically you saying that you know that there is one, right? Seller obligations, the seller is responsible for providing evidence of title and payoff statement and non-foreign status. Those are all documents that they supply to the attorney, right? So that's part of the title work that the attorney is doing on your behalf. Authorization to disclose information. The seller is also disclosing all of their information, mailing address and all of that stuff. All right, access to property. The seller is responsible for providing us reasonable access to the property for inspections, appraisals, walkthroughs, and the like. Seller is responsible for removing all of their property prior to closing. Okay. All right, the seller, this is basically saying that the seller is saying that at closing, all liens will be taken care of. So there will not be any of the seller's debt passing on to you, and that they will be giving you good title, legal access, and a general warranty deed, which means a nice clean title for the house that you're purchasing. All right. All of these are just pretty straightforward. This is saying these lines are for you to put exactly who you want to be on the deed. This is where, if we were asking the seller to pay any closing costs, we'd put it here under I. Alrighty. This is also saying that the seller is responsible for paying the fees associated with the change in ownership for the HOA. All right. Confirm special assessment. Seller is responsible for paying those. Late listing penalties are paid by the seller. Negotiated repairs and improvements. If the seller agrees to do anything, we'll get that in writing. And then those negotiated repairs and improvements shall be made in a good and workmanlike manner, and the buyer shall have the right to verify the same prior to settlement. Meaning, if the seller agreed to do it, then we're going to check and make sure that they did it. And if there are any issues with the work that's been done, we'll bring that to their attention. All right, seller's failure to comply or breach. If the seller fails to materially comply with any of the seller's obligations under this paragraph, or seller this contract and buyer elects to terminate this contract as a result of such failure or breach, then the earnest money deposit and the due diligence shall be refunded to the buyer, and the seller shall reimburse to buyer the reasonable cost associated with or actually incurred by buyer in connection with buyer's due diligence without affecting any other remedies. All right. And what that means is if the seller breaches the contract, they owe you back all your money. Now, the only way that a seller does breach the contract is by not selling the house or by not doing something that is agreed upon in this contract. Okay. Prorations and adjustments, everything, your taxes and all of that will be prorated. Owners association dues are prorated at closing, to where you take over as the buyer from the day after closing through the end of the year, and the seller is responsible from the beginning of the year up to the day of closing. Okay, up to and including the day of closing. Home warranty, this is where we say whether or not we're getting a home warranty, who's paying for the home warranty, all of that good stuff. Risk of loss, condition of property at closing. Just real quick, risk of loss means that if this house burns down prior to purchasing the house, that does not terminate the contract. If the house burns down, then the buyer is actually able to collect on the seller's insurance policy for the house. So that's what that risk of loss section is talking about there. Delay in settlement or closing. Both the buyer and the seller have 14 days from the contract, from the date that we set on the contract that we could close. Both have 14 days from that day to get the transaction closed, okay? So if you don't close it by then, and on the 15th day, you are technically in breach of contract and the seller can terminate the contract, okay? Just like if the seller is not able to do whatever it is they're supposed to do within 14 days of closing, then they are in breach of contract. This is where any addendums, buyer possession before closing, all these types of things are right here if we need any of that. All right, we're not going to have to worry about assignments on this one. This is not a tax deferred exchange. And all of this stuff here is pretty self-explanatory, so I'll let you read through that. All right, computation of days. Every day, everything is calendar days, okay? Calendar days and holidays, all of it counts. All right, and then this is where we sign. Now, when you sign it, it's an offer. Once they sign it, it's a contract, okay? Wire fraud, just like on the buyer agency agreement, no one should be asking you for wiring instructions throughout this transaction. So do not give up any banking information. This is where your mailing address will go. We have to fill that out, as well as all the information about both firms, listing agency and the selling firm. And then this is the acknowledgement of money received. So when you pay your due diligence and your earnest money, and those monies are delivered to the seller and to the escrow agent, the seller, well, first, if I give it to a listing agent, the listing agent will sign saying that they received it. And then the seller will also sign saying that they received it from the listing agent. Then down here, the escrow agent will sign saying that they received their earnest money. That just closes the loop of accountability on the money. So that's it. That's the whole 15 pages. If you have any questions about the offer to purchase and contract, please reach out to me. And thank you again for watching.